Search of high school students by school officials. This is a case involving search conducted not by the police, but by school officials for searching high school students. So the standard is going to be different. Let's see what we have in this case, the case of New Jersey versus T.L.O. T.L.O. was a student in the New Jersey high school, and then she and another girl, they smoked cigarettes in a school bathroom, and the teacher saw that, and then the teacher reported them to the assistant principal of the school. So this assistant principal called T.L.O. to his office, and over there he searched T.L.O.'s purse. And as a result, he found cigarettes and also marijuana. And as a result, T.L.O. was adjudicated a juvenile delinquent and sentenced to probation. And then T.L.O. appealed this case to the U.S. Supreme Court, claiming the school official's search was illegal. So the issue in the case was the circumstances under which school officials may search students. So let's first look at some arguments made by the state of New Jersey. The state of New Jersey, of course, argued this school official's search was justified. So the state of New Jersey actually made several arguments. The first issue was whether this search of students by school officials should be governed by the Fourth Amendment or not. The state of New Jersey made this argument. The state of New Jersey argued this search of students by school officials should not be governed by the Fourth Amendment because when students went to school, teachers and school officials, they were just like students' parents. So because of this relationship, this relationship like parents and children relationship, so the state of New Jersey argued this Fourth Amendment should not apply to the search conducted by school officials. We know if a student's parents want to search the student, of course, that search would not be governed by the Fourth Amendment. If the student's mom wants to look at what her child has in her backpack, of course, the mother would not really. The child cannot say, if you want to look at what I have in my backpack, you have to have a probable cause. You have to have a warrant. Of course, that is cannot be the case. The parents, of course, if the parent wants to conduct a search of his or her own child, of course, no Fourth Amendment would apply because parents, they are not state actors. We already said for the Constitution to apply, we have this state actor requirement. But in this case, the court rejected the state of New Jersey's argument. The court said you cannot really say you're in a position of a parent because public school is a state actor, because this public school actually carries out the state's educational policies. So the court said, indeed, school officials' search of students, actually this search is governed by the Fourth Amendment. The second argument made by the state of New Jersey is that the state argued the student should not have a legitimate expectation of privacy in items brought to school that were unnecessary for school study. So in this case, this T.L.O. brought these cigarettes and marijuana to school. So the state of New Jersey argued these cigarettes and also marijuana, they are necessary for the school study. So if the school officials search her purse, that would not be in violation of her Fourth Amendment, because Fourth Amendment protects the legitimate expectation of privacy, but the state of New Jersey argued students should not have any privacy interest in the items that are brought to school but are necessary for school study. The court also rejected this argument. The court said we cannot really agree with the state of New Jersey because the students should enjoy legitimate expectation of privacy in items unrelated, brought to school but unrelated to school study. The court said the students may want to bring these personal hygiene items and personal letters, keys to the home, and also pictures of their little sisters and brothers. The court said you cannot really say the students should have no legitimate expectation of privacy in these items, and if a school teacher wants to search this item, and then the teachers and the school officials can search these items, the court said we cannot really go that far. And then the court said students indeed enjoy legitimate expectation of privacy in these items brought to school unnecessary that are not related to the school study. The court said students should enjoy legitimate expectation of privacy in these items. But even though that is the case, the court said now we need to discuss the standard for conducting search of students by school officials. The court said we should not really ask school officials to follow the same standard as the standard that is followed by the police, because we know if a police want to conduct a search, they need probable cause, they need warrant. But the court said in a school setting, because the school officials need to maintain the school discipline, so we cannot really have this formal requirement, even though we recognize the students should have this protection of the Fourth Amendment, but we should have a more relaxed standard in regulating under what kind of circumstances school officials may search students. So the court said the standard we want to set is a standard of reasonableness. Because we know Fourth Amendment protects against unreasonable searches and seizures. So the court said we want to set up a standard that is a reasonableness standard. So under this reasonableness standard, the school officials do not need a probable cause, do not need a warrant to conduct a search. The court said the school officials need to conduct this twofold inquiry to determine whether this search conducted by them would be within, would be in satisfaction, would satisfy these Fourth Amendment requirements. So this twofold inquiry is this. The first one is there is a reasonable suspicion. We need to notice, not probable cause. There is a reasonable suspicion that the student is engaged in unlawful conduct or conduct of infraction of school rules. There are 2 points we need to take note in this first inquiry. The first one is there is no probable cause requirement. We know probable cause is a higher requirement than reasonable suspicion. So for school officials, it is only required that school officials have a reasonable suspicion to believe the students is engaged in some wrongdoing. So that is one point we need to pay attention to. Another point is it is not. There's a reasonable suspicion that the students is engaged in a crime. If there is a reasonable suspicion that the student committed a crime, of course, that would give the school officials sufficient reason to conduct the search. But it is not necessary, for there is a reasonable suspicion that the students is engaged in unlawful conduct. The school officials can search the student if there's a reasonable suspicion that the student is engaged in the conduct of infraction of school rules. So long as there is a reasonable suspicion to believe the students either committed a crime or committed act that is in violation of the school rules, so the school officials can search. So it is not a reasonable suspicion that the student committed a crime. It is a reasonable suspicion that the students either committed a crime or engaged in conduct of infraction of school rules. So that is a much lower standard than the standard the police must follow in conducting a search. Here, I think it is important for us to know, if a police would go to the school to search a student, the police must follow the regular standard. The police, under what kind of circumstances, the police may search a student, the same rule. The police must have probable cause, the police must have a warrant. But if we are talking about the search conducted by school officials, and then we know that is a reasonable suspicion that the student is engaged in unlawful conduct or conduct of infraction of school rules. That is the first inquiry. The second inquiry is the search is within reasonable scope. So we are already very familiar with this scope analysis. So if the school officials have a reasonable suspicion to conduct the search, and then the second requirement is the search must be within reasonable scope. If this twofold inquiry is satisfied, the school officials' search should be considered reasonable. The application of the twofold inquiry in T.L.O. Last video we discussed for the school officials to search students, they must follow this twofold inquiry. The twofold inquiry is one is there is a reasonable suspicion to conduct the search. The second one is the search must be within the reasonable scope. So the court, after setting this twofold inquiry standard, the court actually applied this twofold inquiry to the facts of this case of T.L.O. So in the case, in this T.L.O. case, actually, there is not only one search. There were actually two separate searches. One search was for the cigarettes. Another one was for marijuana. So we need to analyze in these two searches whether these school officials satisfied this twofold inquiry. First, let's look at this search for cigarettes. We know this T.L.O. and another girl smoked cigarettes in the school bathroom, and then a teacher actually saw them smoking over there. So the teacher reported this incident to the school official. So this teacher's reporting, we know that would be reasonable suspicion, because these two girls, they were smoking over there. That was in violation of the school rules. So if that was reported, and then of course we know that would constitute reasonable suspicion for the school officials to conduct a search for cigarettes. So we know in this search for cigarettes, and then there was a reasonable suspicion to believe T.L.O. was engaged in an act that was in violation of the school rules, because the school rules, according to the school rules, and the students, they could not smoke in school. So we had this reasonable suspicion that the students was engaged in a conduct that is in infraction of school rules. And then we need to examine whether this search was within the reasonable scope. And then the court said the search was within the reasonable scope, because where did the school official search? T.L.O had this purse, very large purse with several compartments. So the school official searched T.L.O.'s purse. So we know this search should be considered within the reasonable scope. Why? Because cigarettes could be found in T.L.O.'s purse. So if the issue is we want to find these cigarettes because students smoked cigarettes in violation of the school rules, where could the officer where could this school official search? And then if the school official searched T.L.O.'s purse, that was within the reasonable scope of the search, because cigarettes could be found in the purse. We know this because of that, and we know in this search for cigarettes, the school officials satisfied this twofold inquiry. There was a reasonable suspicion, and also the search was within the reasonable scope. And then let's look at this second search. The second search was for marijuana. And then, once again, we need to analyze whether there was a reasonable suspicion and whether the search was within the reasonable scope. And for this reasonable suspicion, while searching the first compartment of the purse, the school official noticed these rolling papers for marijuana use. Of course, there were also index cards indicating who actually owed T.L.O. money for selling marijuana. So this would constitute the reasonable suspicion to believe T.L.O. was engaged in marijuana dealing in school. That was clear, because the evidence we had this very strong evidence indicating T.L.O. was engaged in dealing with marijuana. And then the school official proceeded to search a different compartment of the purse. So this search of a different compartment of the purse, this search was within the reasonable scope. Why? Because marijuana could be found in a different compartment of the purse. So in that sense, this search once again was within the reasonable scope. So if we analyze the search for marijuana, the court also said the school official satisfied this twofold inquiry. There was a reasonable suspicion to believe T.L.O. was engaged in marijuana use, so to search for this marijuana, and then it was within the reasonable scope for this school official to open the second compartment of the purse. So this search for marijuana was also satisfied, this twofold inquiry. So I think it is very good the court actually analyzed this, how we should apply this twofold inquiry in this school officials' search of students. So because in these two separate searches, in each one of these two searches, the school officials satisfied this twofold inquiry. So the ruling of the court is the search of T.L.O. by this school official was legal. Was not in violation of the Fourth Amendment. So that was the ruling of the court. So in this case, it is important for us to remember under what circumstances school officials may search students. In this case, once again, it's not a case about search conducted by the police, but the circumstances under which school officials may search students. We know the standard set by the court is not high. So long as there is a reasonable suspicion to believe a student is engaged in a school rule violation, and then the official or teacher could search this student. And then for this search to be reasonable, so long as they also keep the search within the reasonable scope.